I chose to write a book because it was, to me, perhaps the biggest legal story in decades that I had a chance to follow as it unfolded. The Journal sent me down to Washington in October from New York in October 2001 to cover the legal aftermath of 9/11. And as all kinds of things were happening, including the bill that became known as the Patriot Act, were moving through Congress, I got wind of work in the Bush administration to authorize military tribunals, what they call military commissions, to prosecute the people behind 9/11. That was the plan, and I thought that was an astounding development, because this type of justice is a sort of ad hoc sort of trial that has occasionally been held by the United States during or after wartime. These hadn't been held since World War II, and so it was a dormant area of law that suddenly might be very much alive. And so I followed that. The President Bush issued his order in November of 2001, and it was a remarkable document because it laid out a concept of trial that was it would be unrecognizable in modern courtrooms. It was drafted from a document that FDR had signed in 1942, shortly after Pearl Harbor, that had authorized a single specific trial of 8 Nazi saboteurs. And that was a secret trial that was held in the Department of Justice building. The Supreme Court very quickly, in a secret proceeding, approved it, and 6 of those 8 were electrocuted within days. 2 later had their sentences commuted. And it was a remarkable historical incident in the 1940s. This document that President Bush signed envisioned a similar type of proceeding, not as one trial for a handful of people who had been picked up during a sabotage operation inside the United States, but as a permanent new form of justice going forward, one that would be wholly walled off from the existing federal courts, wholly walled off from any kind of congressional oversight. So that was the legal origin, and that was at a place before the United States had captured anybody, before Guantanamo had been selected as a place to hold them. So it was a legal story. And what I have done over the past year since then is covered the way that project has unfolded. And what's going on now, in some ways, is very different from what could have taken place under that initial order. On the other hand, in some ways, it is tied to that, because the people who are subject to those trials are people like Mr. Slahi. Now, he has not been charged since Colonel Couch filed that memo. No one else apparently has been willing to take up the case either.
He hasn't been charged. How long has he been held?
He has been held a decade.
But, the interesting thing in your account, it's a fascinating account, not only because you go into the history of military commissions from the time of George Washington to now, but you also detail the behind-the-scenes battles that occurred within the Bush administration. The executive order that Bush signed, apparently he didn't even bother to read it very carefully. As you explained, he was on his way to his ranch in Texas at the time, but that the battles that occurred between David Addington, John Yoo, Attorney General Ashcroft, there was a real tug of war within the administration over these military commissions.
Well, that's right, because the commissions project, it was not something that arose because the Justice Department or the Defense Department or the CIA said, gosh, we don't know how we're going to deal with this terrorist organization. Our justice system is incapable of handling it. We just don't know how to handle it. We need to create something brand new to solve this problem. And then they studied different options and came up with this. It didn't arise that way. It was a top-down idea. There were a number of people in the administration who had been thinking about this for many years. In fact, since the 1980s, following the Pan Am 103 bombing, the airliner that blew up over Scotland, this idea had been circulating in some conservative legal circles to resurrect this form of justice. So it was a top-down kind of idea, and other people in the administration weren't big fans of it. And one, of course, as you point out, was Attorney General Ashcroft. Some people found that surprising when they learned that in the book, because right after 9/11, people who were there at the time might remember he was the face of the administration's response, and he was highly criticized by civil libertarians for what they said was a very harsh reaction to 9/11. But behind the scenes, he was trying to preserve the Justice Department's authority to handle criminal prosecutions. Now, his critics, people in some in the Defense Department and some others, said, well, it's just a turf battle over which department's going to have this very important mission. But he was against this. He didn't see a reason to have it because his own staff was opposed to the idea of setting up some alternative to regular prosecutions.
And you note in the book that unlike other types of major decisions like this wasn't circulated among key officials in the administration, so that Condoleezza Rice, National Security Advisor, and Secretary of State Colin Powell had no idea of the decision until it was later announced.
That's right. Well, they learned about it from CNN, and even more important for the way this issue played out was that the CIA was not informed about it. And what has characterized this project for its entire history has been conflict between the CIA and the Department of Defense over the access to evidence. And this, again, given what happened later with the CIA and their secret prison network and so on, might be surprising. But it turns out, at least from my reporting and talking to CIA officials, is that they were quite comfortable with the existing pre-9/11 setup. Here in New York, in the Southern District of New York, they're very experienced prosecutors and judges who deal with very sensitive cases, and the CIA had worked with them for years and was comfortable that they could handle very important classified national security evidence and still get their trials underway. The CIA had no involvement in setting up military commissions, did not know the military officers involved in them, did not have a high regard for a bunch of unknown mid-level people, reservists and so forth, and was very uncooperative with military commissions all the way. Colonel Couch and other prosecutors frequently trying to get information from the CIA, not because they wanted to know what evidence there was, and also because they felt they had a duty to present the defense with anything that could be exculpatory, ran into roadblock after roadblock, and to this day the CIA continues to have a somewhat conflicting relationship with military commissions as recently as a few weeks ago when apparently a CIA censor, unknown to the military judge, briefly blocked the audio transmission from the Guantanamo courtroom.
Explain.
Well, there is right now, I mean, and again, they're military commissions now. They are a modified version of what originally was envisioned. There are a number of changes that make them significantly less unfair than what could have occurred. But there is in the high security courtroom down there, the proceedings take place behind soundproof glass. And if you are in the press and you're there watching, or if you're watching the video feed here on the mainland at Fort Meade, Maryland, there is a 40-second delay. So what you're seeing is actually taking place 40 seconds in the future from what you're hearing. And that is so government censors can cut the feed if what they deem to be secret information is released in the courtroom by a witness or a prisoner or a lawyer or what have you. So that button has been pushed several times. Up until now, it had always been pushed by the courtroom security officer. Most recently, it was pushed by someone who the judge didn't even know was listening, and we assume that it was the CIA because it has classification authority, as they say in government speak, over this information. Now, to be fair, in every instance, the military judge has concluded that the censor was in error, and what was said during that period was put back on the record. So there hasn't actually been anything said in that courtroom that has been kept down, but that potential is there.
The trajectory from President Bush to President Obama, what President Obama did?
Well, President Bush's initial order, which envisioned this sort of legal time machine going back to 1942, the Supreme Court threw out that project in 2006 in a very long, almost 80-page opinion by Justice John Paul Stevens, said that the Bush administration had misread the legal precedents and that the president lacked authority to set up this system. So a number of things happened after that, but the end result was a bill that Congress passed in 2006 called the Military Commissions Act, which authorized a version of military commissions, which didn't look anything like U.S. district courts, but was also considerably more fair than what President Bush initially had in mind. And one reason was that the Bush order said, no one who's convicted here has any appeal to the federal courts. I will have the last word. The statute says, actually, the federal courts do get final oversight of military commissions. President Obama did not support that. He thought it was not fair enough. And he made a lot of statements during the campaign for president in 2008 suggesting tremendous skepticism for military commissions and saying that both civilian courts and the existing military justice system, the one that Colonel Couch was trained in, and other military lawyers, that courts martial that prosecute service members, that either of those systems would be a better way to go. Once he took office, he got a lot of advice, conflicting advice over this, and he chose to take a sort of middle path. He asked, what changes in military commissions do you need to do to make them fair enough? And a number were proposed involving how hearsay can be admitted, a few other things. And he sent those to Congress in 2009. Those changes were adopted, and military commissions were reauthorized. So now we're basically on Commissions 3.0, which looks something in between what President Bush had in mind, but not a district court.
The case of Habib, very complex, and again, Jess does a really good job of covering it in the book. But briefly, it was an individual. He was of Egyptian nationality, but that had obtained Australian citizenship. I was asked to review the evidence in that case to determine what charges could be brought. Based upon the evidence that I was presented, I couldn't see a charge because merely being affiliated with Al-Qaeda does not rise to the level of an offense under the law of armed conflict. And ultimately, Habib was released back to Australia within a couple of weeks of the final assessment that we made in his case.
Although he was held for years
As for the second
before.
part of your question as to how he was. As to your second question about how I feel about military commissions now, what I would say is I am familiar with some of the participants in the current iteration of military commissions. Judge Pohl, the chief prosecutor, Brigadier General Mark Martins, and some of the defense attorneys. In my view, each one of these groups of people are doing their level best to work within this process that's been established, and that tension is a healthy tension when it comes to arriving at justice. And so, at least my confidence is within the people that I know that are participating in the process, and that I believe are doing their level best to see that justice is done, especially in these cases of the 9/11 conspirators. It's my opinion that these criminal prosecutions of the 9/11 conspirators are the most significant criminal prosecutions in the history of the nation.